How y'all doing? I'm Chris, and this is Bama Law, and we're gonna go and review, if it goes well, Karen Read's trial day 11. I've had a few days off. I've had work to actually do, but I'm gonna hopefully be able to give you some great commentary and overall whining um, as to the what happens in this trial. I am an attorney, licensed in the state of Alabama. Sorry, my chair's messing up. I'm a licensed attorney in the state of Alabama, almost 15 years. Um, I've done probably, oh God, I've done a lot of criminal trial cases. Um, Mostly, I'd probably say out of everything I've done in that time, 80% criminal. You could probably say, I don't know, because the last 3 years I've done mostly just civil, um, mostly for in-house counsel work. Get burned out, and my my child was the victim of a pretty severe crime. So I thought it best to, at the time, and up until now, recently, to not do criminal law. I mean, it's not a good idea if you know you're a victim and you may have bias or whatnot. So it's taken some time, but I'm back. I'm back, and I service the North Alabama area. And anyway, I'm not an or I am an attorney. I am licensed, but I'm not your attorney. Just so you know that. Don't ask for advice. I'm not going to give you advice. Don't take any of this as advice because it sure as hell ain't. It's just me whining and complaining and opining on the trial. So let's see what happens, and let's see what kind of crazy nightmare the Commonwealth of Massachusetts can cook up today. All right, let me get this shared. And there we go. Yay, Judge Bev. Yeah, God, she's pretty damn biased. It's not uncommon for a judge to be biased. I hate to say that, but it's true. It's true. I'm sorry, it's true. Most of your judges are going to be biased. I don't know why. I I really don't, because in the end of the day, well, I do know why. They want to get reelected. So if you've got a client that is like her, that may or may not be guilty, and they're afraid that the public outcry will be, how could you let this woman get off? It's like, well, their first response would be, I didn't. The jury did. Not my problem. They want to make sure they get reelected, and that's what happens. It's all about politics in the end. But not all judges are biased, but I would say majority are, whether it be towards a criminal client or towards the state. Some towards a client, very rarely. But your worst is going to be in domestic relations courts. Holy crap, you're going to find bias. Sometimes it's against the women, but it's usually, if you're a dude, especially a black dude, you're just you're fucked. I don't know another word to say. You're just fucked. Especially if you've just come out of prison. I can't count the number of dudes I've had to represent, been appointed, or hired by their family, and they just get out, after doing a nickel or a dime. That means 5 to 10 years. And it's surprise, you owe child support. And surprise, you get to pay it or go to jail. And surprise, you can pay the 10,000 that you owe, or 20,000 you owe, or 5,000 of it, or you don't get out of the county jail, which is way worse than prison. So anyway, I don't know why she's like this, other than the reasons I just gave. So with that being said, let's go for it.
Discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. You also able to
And it'd be nice if I could hear her damn voice. What the hell's wrong with the audio?
Research or investigation into this case?
I wonder.
You want to say yes or no to affirmative?
God, I wonder if Law and Crime's better. Let me see.
Okay.
Well, shit. Come on. Come on. Speed it up. Come on. You can do it. Let's go. We got all day.
Okay. So I'm told counsel wants to see me as the jury's coming
Yeah,
over.
it
Why don't you
sucks.
come up to sidebar?
They both suck. So, it is what it is. We'll just have to suffer. I don't really want the chat. That dude needs some spray paint on the top of his head, or a yarmulke one. I don't know. I feel for him. I mean, I'm losing mine up front, but bro, just yeah. Ooh. I'm guessing the family. All right, speed her up. Ooh, let me go to my setting of playback. I know it's going to get caught up too quick. Damn, how long of a sidebar is this? I mean, I've seen. How long was that? It was like a 10-minute sidebar. There's nothing a judge has to say that I'd really want to hear for that long, unless she's chewing me out. That happens a lot. You know, counsel, I don't want to hear blah, blah, blah today. I don't want to hear no bullshit from either side of you. I want you to do your damn job. I want you to, you know, be on the up and up. I've had judges tell me that literally verbatim. No bullshit today. You got it?
Okay, thank you.
Yes, sir. It is weird that she gets to go up and listen to it. I mean, she has a right to do so, but it's kind of bizarre. I'm definitely not used to it. What the hell are they doing?
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Drawn here, give your
Norfolk.
presence, and you shall be heard. God save the
Norfolk
Commonwealth of
County.
Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Were y'all able to not have your head in the damn television? Please don't do so. Please don't listen to radio. Don't get on the internet. All right, who do we have today? Come on, hurry up. Hurry up. Who do we have? Oh, boy.
Thank you. Raise your hand. You solemnly swear the honesty of the court and jury in case I'm hearing the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to Norfolk.
Oh God, his name. Oh my God, his name's Keefe. Oh God. Oh jeez. There's a great show on right now on HBO, The Righteous Gemstones, and there's a guy there named Keefe, not Keith, Keefe, Kief. It's just about how some redneck would pronounce it without teeth. Hey, you going over there to see Keefe? Keefe over there can help you. So here's Keefe. Keefe is on testify today.
District Attorney's Office.
Are you a trooper?
Yes,
When did you first start working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the Academy.
How long was the academy?
Basic training. What
Approximately
in
6
the
months.
goddamn
Did you have any
military?
further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
Oh my God, is
What's
this
your
guy
role at the Norfolk
retarded?
County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's
It's
office.
not uncommon for state police or um, other state type agencies. Oh, my nose is itching. For instance, in Georgia, you've got Georgia Bureau of Investigation. We had ABI in Alabama. Now it's ALEA. It's like a bad stripper name. ALEA, Alabama Law Enforcement Agency, which encompasses a lot, but it's essentially ABI. Those guys would be called. Technically, you could call, say, a sheriff next door to you if you're a police department in the state. You're a small department, you might call the county in to do the case. And I worked for a law enforcement agency in Georgia. It was not we were the larger county, so the cities, if they had a homicide, would call us in to even though it's technically their jurisdiction, they would call us to work it. So it's not abnormal for smaller communities or counties to actually call the state to do the investigation. So
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key?
I
And
was about
doing
to
this
say, didn't we just
That is
hear from a
correct.
Did
guy
you do that?
last
Yes.
week that did this?
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you
That's
arrived
not
at 34
abnormal.
Fairview
That
Road,
is
was there
not
anybody else there?
abnormal for a
Yes.
state
Who was
agency to do that.
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search, very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag
And why would you do that?
to secure it.
Did you document the
How would you become
scene?
aware if there was a piece of
Did you
evidence found?
do
The search team would
photography
alert,
first?
the
Document
supervisor,
it?
Lieutenant Tully, or myself, that there was an item or a
Sketch.
piece of evidence, and Lieutenant
I
Tully would
hope
take
you
a
did a
photograph
sketch
of it,
with
and then I would
measurements
secure the piece of evidence in a bag.
before you
Evidence bag.
just start
Do you know if
picking
those
up
photographs
stuff.
were timestamped?
I believe so.
Your role was to put the evidence in the bag?
You
return it to the
believe
evidence room?
so? Every
Correct.
evidence
Did you
should
do
have a
that? Yes.
timestamp.
If I could begin, I'd like to show you on the screen.
Every one of
Series
them
of
should have a
exhibits. We can start
timestamp
with exhibit
when you
74,
pick it up. And then a chain of
Trooper, do
custody.
you recognize that item?
Yes,
What is it?
that is a black Nike shoe.
Did you see that item that night?
Yes,
74A, please.
Oh, now I can tell it's a shoe.
74B. Thank you. Is that the same sneaker?
yes, sir.
After you were alerted to that sneaker, did you place that
Yeah,
sneaker
I hit
into
on
an evidence bag?
Yes,
Did you bring that item with you
Yeah.
today?
yes,
Car would knock you
Yeah,
out of
gloves.
your shoes.
yes, sir.
I can see that. Yeah.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
They're so formal. All so formal.
Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then
Should
retaped?
be initialed.
Do you write on the outside of the bag?
Yes,
Why do you do that?
to memorialize the date time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
Should also have done it over the tape. Should show that you sealed it. It's going to have to be redone. once he's done with it. Dude, just cut it along the top, bro.
Sorry. With the court's permission, can he show the item?
Yes.
Yeah, at least he didn't cut it open completely and butcher it.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any objections, Dean? 677.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who's collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times. Then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
Yeah, when it's collected.
I'd like to move now to Exhibit 75, please.
And then you initial over the tape, tape line, and
And preferably
write
75A.
the date and usually time.
Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
I'll be right back.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items, there are stickers. Did you put the stickers on them? Do
I do not.
you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There is another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
You could put that back in the bag, please. I'd move this into evidence, please.
Okay. So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to
Yeah,
remove that
okay.
chip. I'd like you to safely secure it, bring it with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
So we're going to mark the little chip.
You
Ms.
would like
Giannetti
mark it?
asked to
Okay.
mark that.
They're gonna mock
Then we're
it.
going to submit that for identification. So
Why are
the
you
small
gonna
chip
make
is
fun of
secure.
it?
Madam Court Reporter has an envelope.
Oh, Mark.
Thank you very much.
You're going to mark it. Oh, okay.
678.
Thank you.
Exhibit BB.
Mark it and mark
Thank
it.
you. Trooper, we have one more bag. of items to
Ambulance
go through.
chasers.
Yes.
Could I have exhibit
We should
73,
not
please?
be able to advertise as lawyers. That should be the last thing we can do. Pharmaceutical companies,
Sir, if you could look at exhibit
doctors,
73
and
on the
lawyers
screen, do you recognize
not
that?
be able to advertise.
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. You recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I move this into evidence as an exhibit, please.
There's no objection, Mr. Yannetti?
There's no objection.
679.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to quote? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Oh, Lord. We got to go through this shit again. Let me speed it up for us.
Thank you, Trooper Keith.
Thank you, sir.
All right, any questions, Mr. Yannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keith, you testified that you received the cell phone of Jennifer McCabe and of Terry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
And
Why is there
that would
two
be
different
on the phone
guys
as well, because it identifies
testifying to the same
specific
stuff?
iPhone 11 that Jennifer McCabe had, correct?
Correct.
The
Not-
password was
Not
provided on that
understanding
consent
why
form,
you would have
Yes.
and the form was
two
signed correct,
forensic
Yes.
by both
phone
Jennifer
guys.
McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the
Unless he's just the one that took
timing of the
it.
signing of
Maybe
that
that's
form,
it.
Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list the time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And
A
what was the
refreshing
date and time that you indicated?
recollection.
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08
It's
p.m.
The
allowable.
document that I handed you is
Someone
not an
can't
original, correct?
remember.
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor,
Is
please?
there an objection, Mr. Brennan?
No, subject to redaction.
So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keith, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not homicide investigation, no.
You have not yet?
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor?
Okay.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office? Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up to me when you're done.
Fascinating. Trooper, are you retarded? Let's speed it up there, buddy.
And, I'm sorry, Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh.
Sure, go ahead.
Jesus Christ almighty. Yeah.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking this, you retrieved videos from both the Waterfall Bar and Grill and CF McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from CF McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
Oh, I'm sorry. Again, if you read that silently to yourself and look up at me when you're done.
Apparently, Gallup just released their a poll, annual professional ethics survey, and judges hit an all-time low. And I'm not surprised because judges tend to not be ethical anymore. Don't know why. I just don't know why. Maybe it's not the ethics that's the issue. It's just stupidity. Because again,
Okay.
only
Having
re-
reviewed that report,
you don't
does
need
that
to be
refresh your
special
memory
to be a
about
judge.
Michael Proctor being the one to write the report on the
Run.
analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And that, by the way, I said waterfall. Is that C.F. McCarthy's there?
Isn't Proctor the guy that
this
got
is C.F. McCarthy.
Okay, I meant C.F.
suspended
McCarthy.
or
He was the one to
fired?
review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes,
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Here we go. Number one. No, this is number 2 for the day. Number 2 sidebar. Oh my God, they're going to kill us with this.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes,
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
he could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes,
That was done at the medical examiner's office
the medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes,
Had you met her prior to that day?
no,
Had you spoken to her prior to that day?
no,
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us
I
what you knew of
think
what was
Proctor's the guy that got in trouble.
said? With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that.
What, if any,
The hell is the objection
conversations
for?
do you have with Dr.
What is with this
Scorti-Bello
objection
about what
sustained?
your unit's theory was about
Where's
what happened
this-
to John O'Keefe?
What the fuck are they objecting
there
to?
was no theory.
Okay. You did not provide any theory to her,
Mhm.
correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes,
You also learned that there was a small cut above his right eye, correct?
yes,
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report.
Sounds
for
like he was
the exact-
bending over to do
Or-
something and got hit in the head,
If I may have a moment.
whether it be with a pipe or a car. I don't doubt that she accidentally
May I
hit
approach,
him.
Your Honor?
It wouldn't surprise me.
You want this one back?
Oh, please, thank you. So I place another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one.
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit,
Autopsy
you are
sucks.
expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left
I don't even
the
know if
medical
that
examiner's
objection
office,
even.
correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct? You knew when you left that Dr. Scoribello had seen the scratches
Why
or
is it
bites or injuries to
sustained?
John
What's
O'Keefe's
the
arms, correct?
objection?
You knew when you left.
What in
that
the hell are
in
they
your presence,
objecting
Dr.
to?
Scoribello had seen the injuries to John O'Keefe's arm.
Objectable line of question.
Sustained.
Okay, line of question.
May we approach?
Okay.
My
Judge, please
God,
stand up.
I've never seen a judge that biased. Every objection is sustained. Every damn one of them. They could ask the most relevant topic and she would sustain the objection. He can testify to what he had knowledge to. It's relevant. I actually had that cup.
Were you watching Dr. Scoribello
Wally
as
World.
she was conducting the
Had the
autopsy?
same color.
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing. Just ask a different.
What direction was
Oh my
were her eyes facing
God.
when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing
What?
her job conducting the autopsy.
And in order to do
At the
that,
body.
I'm
That's
sorry.
a fucking
looking at the
stupid
body.
question.
Thank
None.
you.
Was
Thank
she
you.
looking at the
And
ceiling? No,
looking
she's
at the
cutting a
you
body
saw
open,
her looking at
idiot.
the body, correct?
Yes.
And looking at the body included the arm, correct?
Yes.
And it was at the arm was not covered up during the
What?
autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious
You
broken
don't
bones, did you?
recall.
I'm not a medical expert.
You just freaking read your report for 20 minutes.
And it is
And
common
you don't
practice
recall.
for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
No.
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scoribello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
He did that.
No, no,
and
no.
he got into the jury. The jury heard it, even though they're not supposed to consider it. They heard it.
So, jurors, this break we're going to take now.
You just started. Oh my God. They just
All right,
started
we're going to
this.
take a break. The lawyers and I have some work that we have to do. So it's a little bit longer break than we normally take. It's a little bit earlier, but we did get a call from you. So we'll take a recess now for the next half hour. I want to come
Half
back.
hour?
All right, report, please. Close your notebook, follow me.
What in the hell is the point? Ooh. God damn it. They cut the feed. I don't.
Seated.
Oh, I thought they were
So
taking
I
a
want to
break.
talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get to the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and then that's a shall.
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings.
Trying to do
Courts,
judicial notice
judicial proceedings of a
based
court
on the
of
record of another
state or
court.
the United States.
Usually this
shall
is only
be
persuasive.
competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor.
He is not
Yes.
happy. He is not happy.
Exhibit CC for ID.
Okay.
Damn,
Thank
she's
you.
biased.
So
And I
assuming
hate
Your
I hate
Honor
to say
determines
that,
that the
but she
seal
is. She's
is the
biased.
seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in
It's an
evidence.
interesting rule.
To the extent the Commonwealth seeks to argue relevancy or
Usually this is just simply persuasive authority, meaning the court can go meh or okay, yeah, I like that. That's good logic. I like it. No different than they're in the First Circuit for the federal courts. If the 11th Circuit, which is Alabama, Georgia, Florida, had a decision that was contrary to something in the First Circuit, that's persuasive. And they don't have to make them follow it, or they don't have to. They can stick to First Circuit.
materiality.
So this
That
rule is unique.
argument is
Kinda
precluded,
cool.
Your Honor, and the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall
All right,
be
judicial
material.
notice is just that where the court goes, okay, this is a fact. It's a fact. That's it. It's fact. It's self-authenticating. That's it. We don't have to go any farther with it. You ain't got to prove nothing. We take it as a fact. For instance, Abraham Lincoln being the, I think, 16th president, if I'm not mistaken. You don't have to prove that. That's just judicial. You can just ask the judge, take judicial notice. If you have a highway out in front of the courthouse that an accident was on, and the other side saying, well, you can't prove that it was Highway 413. And if it's known, the judge can go, look, I drive it every day. It's Highway 413. Yeah. So that's what they're trying to get, is just judicial notice. I'm guessing for a case.
So the drafters of this rule knew how to put in a
And she is not happy
qualification or
about it.
condition
Her
when they
attitude.
introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what.
In one area, right? One specific area?
Well, you can call it.
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas.
This is
It's
unique.
FLH, frequent location history.
Right.
But what the
This is
court
different.
also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
That would be correct.
Exactly, Your
No
Honor.
one has
What
it.
is it that, so you want to put in her report and question her about
From another
proceeding
state.
in Maryland? I need to know exactly what you're asking
Yeah.
me to allow.
Give you the answer,
He's right
Your
on
Honor.
that.
Okay.
This isn't making
It's a
sense.
very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine.
Celebrite?
and come to a conclusion
No,
about that
Cellbrite.
timestamp. She is
Cellbrite.
not using Apple source code to find out where that's located specifically in the
Not
phone and what
Celebrite.
it means. She is using a surrogate to do that. And I want to cross-examine her on the topic, using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it. And that means her testimony on 227
Okay.
is not reliable. I'm not looking to exclude it. I'm looking
That's
to toss
interesting.
her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked
Mark.
about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on
Daubert
significant.
is a standard of evidence, or a standard for an expert witness to testify, a standard for reviewing scientific evidence. We don't use that in Alabama. We use the Fry rule, which is older, much older. Daubert came out of a federal case, and most states have adopted it, except Alabama and a few others.
Location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say
Sounds
she
like she
was wrong.
sucks.
It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way
That's
to try to
true.
cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of
i.e. he's a
relevance to
retard.
materiality. There's
That's
none.
That's a good
There's
way
none.
of putting
This
it.
is not a
He's trying to be
denouncement.
polite.
She hasn't been found incredible. There's nothing about her
Incredible,
methodology that has been
not
rejected
credible.
by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue.
Judge
with
is going to
Mr. Whitmer,
deny this. I can tell
Right,
you right
this was
now.
not raised with.
I'll be
Mr.
shocked if she
Oh, it
does.
was. The 227 timestamp would.
No, that was raised, but this, what was problematic.
I can't get over
in
this chick
Maryland,
here
The same thing that was problematic in Arrington.
speaking
That's
into a
correct,
microphone
Your Honor. It wasn't
instead of
raised
typing.
because Mr. Whiffen has not been Daubertized with regard to.
Daubertized?
Source codes, and if I could,
I've
Your Honor,
never heard Daubertized?
Mr. Brennan has made a relevance argument. He keeps anticipating.
Admitted under the
my
Daubert
loss,
doctrine?
which he has incorrect by saying it's not relevant.
God, people
That
just
doesn't
make
go
shit
to
up.
the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the state Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in
Yeah,
conclusion,
he's
Your
probably
Honor,
entitled to
the
do so.
fact that how she tried to
I
get
just don't know if
around
using
Apple's
another
source
state's
code for
ruling is a good way to go
methodology
around it.
in the Herrera case, she got Daubertized on because it wasn't reliable.
There we go,
That's
Daubertized.
exactly what I want to cross her on, is her reliability.
Guys,
how
don't do
she's
that.
trying to get around them.
If you're
In
going to be a
this
lawyer,
case,
don't make up
it's
shit.
just basic cross-examination.
You just sound stupid.
You can see the plan to dehumanize somebody, Daubertized, to use a term
Yeah, I don't.
to suggest some
Yeah.
type of conclusion that has no basis in fact, as an attempt to just dehumanize
That was
her
not a good
and
idea
limit
to
her
use that
testimony
word.
and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if a expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about.
It's not a bad argument.
Manner, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor,
Which
this
is the
decision, how you
basis of
impeach an
Daubert.
expert, but one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Daubertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability.
There
So
you
in
go.
conclusion, Your
Now
Honor,
get
the
to it,
Herrera
son.
case,
There you go.
she was deemed not reliable. That's
You want to show that,
competency.
yes, you can do that. You
In
can
any
show that an
expert that's
expert's not
been
reliable.
deemed that you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court.
Okay.
And one part is the
Yeah, I mean,
location. She has in her PowerPoint she's going to testify.
Do you
Yeah,
intend to
she's-
introduce that, Mr. Brennan?
It's not significant locations. There are
Ah,
locations in the database.
yeah, I mean, if she's been, yeah, no, if she's been held to be unreliable in another jurisdiction for testimony as an expert witness, he's got the he should have the right to be able to impeach her on that. I mean, that's I mean, that's fair. It's also a big deal because of what if her standards are not correct? What if they're low? What if she has low standards? So, yeah, I think $10. The judge rules against him. $10.
Case that developed the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis.
Because you invoke the Constitution,
This is a totally
dipshit.
separate subject.
That's what you
Or an
do.
opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion. It wasn't this methodology for the opinions that she's going to offer in this case. And so if you
No,
look
but
at
it
the
goes to her
case,
credibility.
It is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point.
That he's
This
correct
has
about.
nothing
If
to
it
do
has
with
to
her
do with
opinion
the
whatsoever.
basis of them
It's just
and
an
their
attempt to try
testimony
to
and how they get to
endorse
it,
the defense's attempt
how they're
to
an
suggest she's
expert.
not credible by
In other
hiding
words, you
behind
have
the
to-
shield of a
if-
different judge and
If there is an issue with their credibility as far as how they become an expert witness or why they're an expert witness, yes, he's correct. You know, I don't have the case in front of me. I don't know. I don't know what the judge said. You know, she's going to have to take it back and read it, which probably is not short. It'd probably take her an hour. I still think she's probably going to rule for the prosecution. I mean, she always does. So, I mean, it's like a 90-10. It's pretty bad. I mean, yeah, it's pretty bad.
distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's
It-
not an appellate
It is,
decision.
Your Honor. It is, Your Honor. It is the equivalent. I respectfully don't think that the level of
Superior
court
court
is
would
at
be
all
like in a lot
relevant.
of states,
Any
a circuit court.
Unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her.
That's a real
The
interesting
final
That does not
sentence,
exist in
the
Alabama.
decretal, section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this: if they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone call.
And to get some gluten-free Oreos.
If I could avoid talking about
God, I hate
227, I
celiac.
would, but it is
Some,
necessary for the
super
basis of her
caffeine.
opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence, but not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
But I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue.
Okay.
Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggered.
This is where you get deep into the
actually
rules of
triggering in a
evidence.
legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the the right respectfully to cross-examine on the issue that they're putting in issue. And they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not
So-
raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here.
Your Honor, may I ask what you...
Dude, it's not that difficult.
I
Just
just,
make a
I just want to
decision
know,
and
is
roll
she
with
here?
Yes, Your
and
Honor.
roll with it.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Here we go again. This is a complete, it's starting to become a train wreck. This is going to be a damn train wreck of a case. There is no reason every time they turn around and fart that they have to freaking have a sidebar. Well, he might be, maybe she's got something that's private she's got to do or something. I don't know. That would be permissible on the sidebar. Say, hey, yeah, we need to get her out of here by Friday. You know, she's got a funeral to attend. That's valid. But damn. I guess I'm gonna cut off here when she goes on her hour break, and I'll come back when she does. So I guess I need to make this I guess I should label this part 1. God, most Alabama judges are not going to do that. They're just going to rule right there. Just that's it. Let's see, part 1 a.m. Yeah, I'm gonna save that. Good. Now I've got it labeled. Part 1 in the AM. Can I please skip ahead? God, please let me skip ahead. Oh, I have some time. Oh, no. Really? They're actually going to go to break?
And I'll tell you what, having a great lawyer matters.
Yeah, they're going to go to break.
Hey there, Karen Read Trial watchers. You know what a lot of the...
Yeah. So it looks like that's going to be it on that one. I'm not sure if we've already seen that. Let's see. This one is NBC 10 Boston. I guess we'll just Jesus, this is retarded. I guess we'll just come back and pick it up when they're when they come back. I'll just come back live and do it at that time. All right. Well, thanks for bearing with me. This has been an utter waste of time this morning, unfortunately. We learned a little bit about their peculiar method of admitting evidence based upon a certified court record in another state to get judicial notice. So at least we've gotten that. And then we already knew that this is a Daubert state. So, I tell you what, maybe we can burn some time. Let's see here. Let me see if I can't pull this up. Nah, come on. I'm going to try to contrast Daubert versus Fry. Yeah, let me see. Present. My chat GPT. Be easier to do it that way. Perfect. I think. Yeah, there we go. Daubert versus Fry refers to two different legal standards used by courts in the United States to determine the admissibility of expert witness testimony. Fry standard. This is what Alabama uses from 1923. Original D.C. Circuit Court. Rule: scientific evidence is admissible only if the technique or theory is generally accepted by the relevant scientific community, meaning in general. So, if somebody breaks an arm and the way to set it is only to, I don't know, to do it a certain way, you only need to prove general acceptance by the relevant scientific community in that area. It's seen as overly rigid and not adaptable, which is true, to newer emerging scientific techniques, because you can argue the opposite all the time. It's still used. Yeah, I did not know New York and California still use it. That's cool. So I guess we're not the only state. I knew there was only a couple, but I didn't expect it to be New York and California. Daubert. This is Daubert is the case. Daubert v. Merrill, Dow Pharmaceuticals. It's from about 35 years ago, I guess, 1993. The Supreme Court ruling. Just because the Supreme Court rules on it doesn't mean it's binding. Okay, that it just deals with, usually it can be, but it can also, like for instance with the abortion case that was done a few years back, and then it can also just be that case in that circuit, or that state in particular, if it's a state court ruling. Replaces Fry in federal courts, and many state courts adopted it. The judges act as a gatekeeper and evaluate the following: whether the theory or technique can be used. Technique can be and has been tested. So they have I think it's 5 or 6 steps they have to do. Whether it has been peer reviewed, its known or potential known error rate. Why can I not get this to highlight? There we go. The existence of standards controlling its operation of what they're testifying to, the actual technique or theory that they're using to testify to scientific standards, and whether it has gained general acceptance. This is just one factor in a Daubert. Applies in federal courts. Rule 702, the rule of evidence 702, governs expert testimony using Daubert. It's the same in Alabama, except that it would be Fry. And then the differences would be Fry. The Fry rule is about general acceptance in the community. Daubert is about scientific validity and relevance, with the judge evaluating reliability through multiple factors, which is what Judge Bev here is having to do. She's got to do that. So she wants to go. Did I get this? Yeah, shared. She's wanting to go and give an actual. She's got to, based on Daubert. She's got to go and read this case, research. That's why she's perturbed, and she should be. They should look. They knew this was coming up. Both sides knew it. They presented their witness list. They know the defense is known. They've just waited until now, until they're going to present it to Sideswiper. So I'm going to agree with her on this. Yeah, she should have been given notice. This is horse hockey. Now she's got to go read the case, cross-reference it, whatever whatever else she's got to do. She's got to damn near brief it, even if it's just in her own mind. And then she's got to make a ruling that's consistent with this rule that they have, this particular rule. So, because this could be an appealable decision. This could also be an appealable decision that gets a case sent back for retrial. So she's going to make sure she does it right. At least I hope she does. So anyway, we'll pick it back up. I'll probably wait until, I don't know, noon or so. But thanks for joining me. If you hit like and subscribe, please leave a comment, leave a question, and I'll answer it. I have no problem doing that. If you would like to learn more about the law, I was thinking about doing a series of videos on the rules of evidence, I don't think anyone's done them. And maybe criminal procedure. Those are the two that guide these trials. Mostly the rules of evidence. And if you don't know them, you're sunk. You're never going to win. I think it would be helpful. At least when I was in law school, it was extremely boring at times, mind-numbingly so. But you without it, you don't understand what's going on. You need someone that has to sit there and interpret stuff. Which is, it's, if that's what you want to do, that's fine. But if any of y'all would like to know, or I don't want to say be taught, learn about the rules of evidence, how they're applicable in trial, how you use them, the objections, why you would object, etc. Please leave a comment, and if I get more than one, I may do a series on it. Okay. All right, y'all. Thanks. See you later. See you in a couple hours, I hope.